今日嘅
Welcome to the meeting of the panel on Administration of Justice and Legal Services. We have 5 items on the agenda to deal with. The first item is information papers issued since the last meeting. There is one. For details, please refer to the agenda. Do we have questions on this item? If not, we move on. Items for discussion at the next meeting. You've all received 3 papers, number CB4344/2023 352. The last is the list of outstanding items for discussion. And then the second paper is Electrical paper number CB4352/2023 This is a letter from Mr. LAM San-keung dated the 21st of March 2023. The third paper is paper number CB4352/2023 This is the Judiciary Administration's response to Mr. LAM San-keung's letter. Mr. LAM San-keung asked the panel to discuss the unduly long listing time and also digitalization of our courts. The administration's response is that it has no objection to putting this item on our list of outstanding items. If members are agreeable, we will add that to our list of items for discussion. Is there any comment? If not, then we will go on. Or rather, we still have to fix the items for discussion for our next meeting, which is scheduled for the 22nd of May at 4:30 p.m. There are 2 suggestions from the administration. One, proposal to amend the Criminal Procedure Ordinance, and second, report on implementation of enhancement measures to the legal aid system. Members, do you have comments? If not, that will be the discussion items for our next meeting. We move on to the third item on our agenda, and that is proposed creation of a principal government counsel post in the Prosecutions Division of the Department of Justice. We have paper CB4344/2023 from the administration. We have representatives from the Law Association, Law Society and Bar Association attending this part of the meeting. Let us welcome Mr. Horace Cheung, Deputy Secretary for Justice, and Ms. Maggie Young, Director of Public Prosecutions, and Ms. Irene Fan, Senior Assistant Director of Public Prosecutions from the Department of Justice. Deputy Secretary, can you please walk us through the paper? Thank you, Chair. Good morning, Chairman and members of the panel. As technology develops, now cybercrime is getting more common and more sophisticated, causing much harm to individuals and corporations, and that may even threaten national security. In 2015, the police set up the Cybersecurity and Technology Crime Bureau to tackle related cases. However, there is no dedicated team in the Department of Justice to handle such cases. The work is shared among different subdivisions within the Public Prosecutions Department. As technology crimes are more sophisticated, and then we should accumulate a pool of expertise and knowledge so that we can understand the development and also the potential risks. So there is an urgent need for the DOJ to create a new position of principal counsel, government counsel, to head a subdivision to tackle this crime. Now, I would like to highlight the salient points of the new position. The number of technology crimes has grown. From 2017, we had 5,567. In 2020, we had more than 10,000. In 2022, we had 22,797 cases. So the number of cases has grown by 3 times within 6 years. As regards the loss, it started $1.3 million. It grew to close to $3 billion in 2020 and over $3 billion in 2022. Now we had online frauds and online blackmail, and the growth has been over 100,000 or 41%. Now this has shown us how complicated and serious the situation is. The number of cases and the financial laws have grown, and there are also very complicated issues such as the authenticity and also the provenance of providence and whether we have sufficient data to deal with such issues. And this involve very detailed legal research, and we have to take reference from a large volume of overseas cases. Now, as the modus operandi gets more sophisticated, we rely on experts of cyber crime to find out the complicated operations behind technology crimes. We need people who are highly knowledgeable and with close liaison with related experts to tackle these crimes. And so there is an urgent demand for the Public Prosecutions Division to set up a new subdivision to tackle technology crimes. For the detailed duties of the subdivision, please refer to para 9 of the paper. With this new subdivision, we'll be able to set up a database of technology crimes. We'll be able to train personnel, and we can also assess the law enforcement agencies, and also the collaboration between the two, and we will be able to respond to the latest development and crime train locally and also overseas, and then we can tackle technology crime. The work nature of the subdivision is very sensitive and complicated. Its leader must be highly knowledgeable with experience to be fully conversant with the constantly evolving technology landscape and have a good idea of the development locally and overseas, so that we can have a team to tackle technology crime and to reduce the potential threat to people's properties and also national security. So it must be led by a principal senior government counsel. For details, please refer to para 11 to 13. Now we have considered other alternatives. We have considered deploying personnel within the DOJ, but the answer is not really feasible. We are providing more pieces of advice to the government. The number has grown from 9,000 odd to 14,000 in 2020, a growth of close to 20%. And the nature of prosecution is now more complicated, and manpower is tight within the department, and it's not possible for the workload to be shared among the subdivisions. In order to tackle technology crime, to safeguard national security and also law and order, please accept our proposal to create a principal government counsel post. We believe the additional nominal annual salary cost will be around $2.7 million, and the full annual average staff cost will be around $3.7 million. We have included sufficient provision in the draft estimates of 2023-24 to meet the cost of the proposal and reflect the resources required in the estimates of subsequent years. Subject to members' approval, we will submit a paper to the ESC and then the FC for approval. Thank you. Thank you, Mr. Zhang, for your briefing. Can I invite Mr. Anson Wong from the Hong Kong Bar Association to comment on the paper? Thank you, Chair. The Bar Association supports the DOJ's proposal to create a principal government counsel post. Hopefully, there can be more resources to the Department of Justice so that the department can have sufficient resources to carry out its work. Thank you. I'd like to know whether the other representative would like to speak as well. No? All right. The next we have Mr. Christopher Yu from the Law Society of Hong Kong. On behalf of the Law Society, we would also like to support the proposal from the DOJ because in terms of cybersecurity and technology crime, we have seen a rising trend in the number of cases. The government should provide sufficient resources for the DOJ to create this new post to head a new subdivision. Thank you, Mr. Yu. Now I open the floor to members. 4 members have pressed the request to speak button. I read out the names here. Ms. Carmen Khan, Ms. Doreen Kong, Ms. Maggie Chen, and Mr. Holden Chow. I will allow 4 minutes each first for both questions and answers. If we have enough time, I can allow a second round. Ms. Carmen Khan, thank you. I speak to support the government's proposal to create a new post of principal government counsel post to head a new subdivision. According to the Deputy Secretary's briefing, we have seen a rapid growth in the number of technology crime cases, and there is also threat to national security. Even though the police have stepped up its enforcement action, we must catch up in terms of our resources for prosecution. So I agree that we should have a subdivision to tackle the challenges associated with the growth in the number of technology crime. Now, I'd like to comment on para 9B particular. It says that it will formally prosecution policies and strategies related to prosecution of technology crimes and the use of digital evidence, and Annex 3, duty, enclosure 3. This is lawyer is going to study the current application of the existing laws and challenges arising from the legal framework. Now we have also studied the LRC's report on cybercrime-related measures and also proposals to legislate. Now, this is the first question. And second question is, given that this is such a special area of law, I'd like to know whether you will enhance the application or the extraterritorial application of the related laws and how you're going to train up the whole team. Thank you.
Thank you, Ms. Carmen Khan, for your support. Indeed, online cybercrimes have multiplied, and we also need to attach greater importance to cases happening outside our jurisdiction. We need to collaborate with the police in tackling cybercrimes. Ms. Carmen Khan mentioned the Law Reform Commission. About cybercrime cases, and out of jurisdiction cases, they are carrying out studies. As far as I know, there are 5 new cybercrimes that are being researched into. After the LRC has made suggestions, the policy bureaus of the government will think whether we will put in place these suggestions. This position to be created will help in this connection. That is whether we will realize the suggestion of the LRC. We will provide professional opinions to the relevant policy bureaus. This is an area of work that we would like to expedite. For this new position to be created, this position holder will not only be responsible for prosecutorial work, the position holder also plays a very important role in the legal area, in terms of legislation. So what about on training? I invite my colleague to take this question. In Hong Kong, the police already has a very professional team. As a first step, we will understand from the police the current situation, targeting new or emerging cases. We will have an understanding of these cases first. Then we will collaborate with overseas and mainland experts. And then we will start making enhancements and understanding the situation facing us. Ms. Doreen Kong. I am also in support of this proposal. I'd like to ask the Deputy Secretary. There will be a team under this new position. There will be a dozen or so supporting staff members. Of course, it would be good if we have a good leader. What about the staff members under this position? Do they have the relevant experience? We cannot just bank on one single person. The staffers working under this position should also be experienced enough to carry out the duties. Regarding financial impact, 2.7 million or so. So, why will the salaries and staff on cost be $3.7 million? I do not quite understand this point. I have another concern. I understand that it is not easy to look for talent in this realm. When we offer such conditions, is it actually quite difficult for us to look for talent? In relation to the portfolio, I'd like to ask the Deputy Secretary regarding Item 7, managing and administering the supervision. Does it cover training? As I understand, legal training is very important. I'd also like the Deputy Secretary to give it some thought. This position holder will have to stay abreast with the market. The position holder will also have to maintain a close dialogue with the Law Society of Hong Kong and the Hong Kong Bar Association. Any response from the administration? Thank you, Ms. Doreen Kong, for supporting us. Ms. Doreen Kong mentioned a couple of questions or issues that I think we should level with the public. Thank you for giving us this opportunity, Ms. Doreen Kong. Indeed, after the creation of this position, there will be redeployment of staff members. We are proposing the creation of a D3 position, under whom there will be 2 assistants, one pitched at D1 and another D2. There are 9 government counsels, as well as 2 supporting officers in the clerical grade. We understand that society is concerned whether we will have to create a lot of positions under this position holder, hence a lot of positions to be created. We have given it some thought. There will be staffers working under this position. But we are going to redeploy officers from other divisions. They are well experienced. Without doubt, after the creation of this D3 position, as we mentioned, the D1 and D2 positions will be redeployed from other subdivisions, and we do not have to come back to the LegCo to apply for funding to create yet another new position. For the other 7 new positions, they will be redeployed, and for the other 2 new positions, we will have to create new positions. Well, we do not actually have to come back to the LegCo to apply for funding. There will be 1 clerical supporting officer. So, after the creation of this D3 position, there will be 2 government counsel and 1 clerical officer. These positions will have to be added, and we will redeploy officers from within our division. The reason for the discrepancy between $3.7 million and $2.7 million stems from the new officers. But then we will not have to come back to the Legislative Council to apply for additional funding. We will make redeployment within our division. What about the professional level to underpin this new position within your division? As I mentioned, regarding how we tackle cyber crimes, when we receive a case that is a cyber crime, we will assess the gravity. Probably it will have, it will be heard in the district court, and we will send it to the district court team to handle it. If it is less severe, for example, it can be handled in the magistrate court, we will send it to the relevant division. So there are actually different colleagues in different subdivisions handling different cases of different severity. After the new subdivision, after this new subdivision is created, it will become a new professional subdivision comprising different officers. So it will be mainly responsible for the emerging new cyber crimes. In this connection, I believe that the community does not have to be worried. These officers are working within our division, but then they are scattered throughout different subdivisions. They are now responsible for different types of prosecutorial work. Ms. Maggie Chan, I speak in support of the paper submitted by the DOJ. But as I learned from the document, this new position will be responsible for a lot of tasks, and there are a lot of different indicators, including strategic steer, monitoring, supervising, providing legal advice, prosecutorial work, etc. My first question is that whether there is any priority. You mentioned strategic steering or strategic leadership. Next, it's my comment instead of a question. We are talking about cyber crimes. In 2021, in 2022, as we can see from the percentage, online scams have seen a substantial growth. On cyber crimes, will we update the code of prosecution so that the public will be informed of any latest situation resulting from your new subdivision? Publicity is very important in relation to online scams. Will it be a focus of the new D3 position to be created? Thank you, Chairman. I will ask my colleague to take this question. In paragraph 11, A, B, C, D, E, F, G, these sub-items will be carried out in parallel. The D3 position will be underpinned by 1 D1 and 1 D2 positions. They will be collaborating with the police to research into the new technology or cyber crimes. There are also current evidence ordinance laws issues. At the same time, this D3 position will be responsible for strategic leadership. the position holder will provide guidelines from a macro perspective. All these will be carried out in parallel as a team. So all these sub-items will be carried out in parallel. On the third question, publicity. Can you give us some comments on the code of prosecution? Indeed, publicity is very important. That is public education, especially in relation to online scams. If there is enough and good public education, there will be less pressure on the prosecution division. In a new subdivision to be created, we will also bolster our work in this connection. Apart from public education, in the police, they also have a dedicated team responsible for investigating cybercrimes. So we will enhance our efforts about publicity. Whether we will update the code of prosecution, well, definitely we will. There are more developments, and it is also getting more complex. So with a new subdivision, we can ensure that we can move with the times in relation to our policies. If you have direct or indirect pecuniary interest, please declare your interest before you speak. Just a reminder to you. Thank you. Next, Mr. Holden Chow. Thank you, Chairman. Of course, I understand with the proliferation of online scams or online crimes, we need additional manpower to tackle this crime. This is understandable, so I support this paper. First, in the document, for the original 4 subdivisions, these 4 positions are responsible for commercial crimes and securities fraud, etc. For the new position, it will be responsible for technology crime. But we understand that they are interlinked actually. For example, securities have to do with cryptocurrency, scam, theft, etc. They leverage very advanced technology and they happen online. I'd like to know, looking forward in the future, what is the division of work between these 2 position holders? I estimate that there will be a lot of overlapping between these 2 subdivisions and there will be a lot of assistance rendered to each other. As a comment, one of the responsibilities is to review the Evidence Ordinance or whether the relevant laws can move with the times. It is just my comment. As we can see, for a lot of cases, technology crimes are developing very fast. Whether we can speedily freeze the relevant assets is very important. Earlier on, Mr. Christopher Hui said that the SFC has been tackling a lot of technology or online crimes, and they have successfully frozen 130 accounts. Just in 2022, there were close to 20,000 cases. So we really need to think whether we can move with the times, whether we can act speedily. There are a lot of changes and there are a lot of transfer methods. So can we really move with the times in relation to freezing the assets?
In fact, you did include a question in your comments. Mr. Zhang. Yes, Mr. Chow is very correct. Cases are now more sophisticated, and it involves different departments and LEAs working together to tackle. And this is not something new within the DOJ. When a case involves various aspects of law, then different subdivisions within the DOJ will cooperate. We have interdepartmental task force set up to tackle these issues. So when dealing with technology crime, as mentioned by Mr. Chow, we have more commercial crimes involving technology. Different subdivisions will work together in the future very closely so that we can have the most professional team to tackle these cases. And that's exactly why we have to set up this subdivision. We want to build up a team not just within the DOJ, but within the SAR government. We should have a most professional team within the government to tackle these cases, and that is the reason why we want to set up a subdivision to catch up with the times. Any other questions? If not, then do we all agree that the paper can be submitted to the ESC for its consideration? All right. Next. The court remote hearing bill, we have got two papers. One is CB 4344/2023-03, a paper provided by the Judiciary Administration. The second paper is paper CB 4344/2023-04, a background brief prepared by the Council's Secretariat. Let us invite representatives from the judiciary to come in first.
司法機構。好，我哋歡迎司法。
Let us welcome Ms. Esther Leung, Judiciary Administrator, and her team. Ms. Leung, when you are ready, can you please brief us on the paper you've provided to the panel? Thank you, Chair. Good morning, Chairman and members of the panel. The Judiciary Administration is here this morning to brief members on the court's remote hearing bill. Now, the judiciary is committed to using technology to enhance our efficiency, and we have introduced various measures for application of new technology, one of which is to promote remote hearings. In the past 3 years, we have over 1,600 remote hearings, and the experience has been positive. We plan to present the court's remote hearing bill to the Council to lay down the legal framework for application operation of remote hearings in Hong Kong to allow the judge and judicial officers to order remote hearings at various levels of court and tribunals where appropriate, having regard to all relevant factors as well as the due requirement of open justice and fair hearing. Now, because of legal constraints, most criminal cases cannot be heard remotely. For instance, the existing law generally requires the defendant to be physically present at different stages. For civil proceedings, where remote hearings may already be permitted under the current law, there are no express provisions setting out how matters are to be handled in a remote mode, and therefore we believe we need to introduce a bill to provide for a legal framework to do this. Now, compared with physical hearing, remote hearings is an option for JJOs, so that we appropriate remote hearings, including a video or voice link, can be used for hearing cases. Now, it is just a mode. It will not affect the legal proceedings. And therefore, in drafting the bill, we have to ensure that the provisions can safeguard the major principles of open justice and fair hearing in conducting remote hearings. In 2021 and 2022, we conducted 2 rounds of consultation to engage the public and stakeholders on the broad principles and policies regarding legislative amendments on remote hearings. We're grateful to stakeholders, including the Law Society and the Bar Association, for their views. All in all, the public have been positive about the proposals. Now, for views received, they're mainly about factors to be considered in conducting remote hearings and legal proceedings that should not have remote hearings, and also the various issues. In light of views received, the judiciary has reviewed the policy and legislative proposals on remote hearing and revised the bill as appropriate. I will invite the Deputy Judiciary Administrator to brief members on the main points of the bill. When it comes to the general policy on remote hearing, there are 3 major points to note. First, whether a case is suitable for remote hearing is a management decision of the court in exercising its management powers. Now, we have to ensure open justice and fair hearing, and a number of factors will have to be considered before remote hearings will be used. And secondly, at specific stages, unless otherwise directed by the court, in order to safeguard the rights of defendants, we are of the view that for first appearance of a defendant before a magistrate, and at the case of judgment, and at the time of his plea, verdict, and sentence, there should be no remote hearing. And thirdly, upon passage of the bill, we are going to use remote hearings more extensively and widely, and in appropriate proceedings, the court will give priority to the use of remote hearings, and we will continue to use remote hearing in suitable civil proceedings. For criminal proceedings, to ensure the parties have sufficient time to get used to this new arrangement, we expect that criminal proceedings will only start to use remote hearings 6 months after the passage of the bill. We will provide more support and assistance, and we will provide bilingual guidance, and we will have a test before actual introduction. We have to receive suggestions from members. We propose that in the 4th quarter of this year, we will submit the bill to the Council. I will now give the floor to Ms. Winky So, the Deputy Judiciary Administrator, to brief members on the main points of the bill. Ms. So, thank you. I would like to brief members on the main points of the bill. Have you switched on the microphone? Chair, I will brief members on the main points of the bill. Part 1 contains the interpretation and application. The application of the bill will involve all various levels of courts. And the second is we will include factors for consideration in the making of a remote hearing order. For instance, the views of the parties, the ability of the parties to engage with and follow the proceeding, the maintenance of the rights of the parties, whether the privileged communication between the parties and the respective legal representatives may be affected because of the use of remote hearings. Now, these are some of the 16 factors to be considered. During public consultation, we received views that parties to litigation may want to make known their views, and there should be ample room for them to do so. The court may make a remote hearing order on its own motion or an application by any party to the proceedings. And if a remote hearing is made, the court may invite parties to the proceedings to make submissions regarding the mode of conducting the proceedings. If the court does not invite parties to make submissions prior to the making of the order, and if any of the parties to the proceedings is dissatisfied with the order, the party may make representation to set aside or vary the court's orders within a reasonable period as specified by the court. Part 3. Operation of remote hearings. I'd like to mention in particular that there are empowering provisions in this part. To state that actually a remote hearing is just the same as a physical setting in all relevant aspects. And so the effect and also the objective of a remote hearing is just the same as a physical hearing, including the powers of a GJO and a participant who attends a hearing or who refuses to attend a hearing will face the same consequence as if it were a physical hearing. And then there are provisions on the administration of an oath and also the serving of documents. Part 4. This is to ensure open justice. Now, for members of the public who are interested, they can sit in a court hearing. This is an important way to safeguard open justice. The same arrangement will be in place for a remote hearing. In the bill, it is said that the court may arrange for open broadcasts of proceedings, because there may be circumstances when it's not feasible for members of the public to attend a physical hearing. For instance, due to public health concerns or safety concerns, or if the whole hearing doesn't take place within the court, there is room for the court to decide whether the members of the public can gain access to such proceedings in the court or not. Part 5, new offenses and penalties, to ensure that the integrity of both physical and remote hearings. Now, in a physical setting, because the proceedings are conducted in public, and there are witnesses present, if there is any unauthorized recording and publishing of court hearings, they can be easily found out, but not so for remote hearings. And so we have to create new offenses to deter unauthorized recording and publishing of court proceedings. Now, if the details of court proceedings are published without any authority, then it is an offense. During public consultation, we received a lot of comments, and we have made a further adjustment to our proposals. First, to expand the scope of the offences to cover unauthorized publishing of authorized recording of court hearings. And the second is to include recklessness in the criminal intent of the offense on unauthorized publishing of authorized or unauthorized recording of court hearings. This is because of the serious consequences caused by unauthorized publishing of court hearings, and we've also made reference to Section 159 AAD of the Crimes Ordinance, which concerns the publication of images originating from commission of the relevant recording offences. And the third is to rationalize the penalty levels. At first, we propose a two-tier penalty structure. The first is unauthorized recording, and the second is unauthorized publishing. For the latter, the penalty is heavier. But then, we believe that the seriousness of penalty should be packed to the gravity of the offences, and that is how severe will be the impact of such acts on legal justice. So by summary conviction, the penalty will be a fine fixed at level 5 and to imprisonment for 2 years, and on conviction, on indictment, to a fine of level 6 and to imprisonment for 5 years. Of course, different levels of penalty will require different standards of proof, and the court can decide based on the gravity of the case in meting out the penalties.
終審法院
On Part 6, provides the Chief Justice with the general power to designate certain types of proceedings as the type of proceedings to be conducted through a remote medium. For cases which will not be heard in a remote setting, they are listed in that list. So, this part provides the Chief Justice with a general power to amend the list. And make rules or give directions on matters which are necessary for the administration and application of provisions of the primary legislation. Regarding Parts 7 and 8, they set out the related and consequential amendments. The Judiciary proposes expanding the scope of summary offenses regarding photo taking in court premises. Section 7 of the Summary Offences Ordinance, Cap 2 to 8. Unless with approval by the Judiciary, anyone taking pictures or audio or video record of any people or thing on court premises will be subject to a penalty. We hope that this plan will be tabled to the Legislative Council in Q4 in 2023. Thank you, DJA. I now invite Mr. Anson Wong, SC, from the Bar Association of Hong Kong to give us comments. Well, on this topic, I will invite Mr. Martin Wong. Last year, the Bar Association gave written submissions on 2 practice directions and other manuals. On the bill, we provided comments on 3 fronts. All of them have to do with penalties and offenses, as we can see in the latest bill. 2 items have already been amended because, well, after our suggestions. That is, from which organization or which individual should the consent be sought. And regarding the uncertainty in the prosecutorial framework, or time frame. It no longer exists. Regarding reasonable defense or justification, we would like to have more illustrations. That said, we understand the difficulty, so we think the current bill is still acceptable. We can also see in the latest bill there are new offenses, and the penalties have already been adjusted. We understand these amendments, and we also support these amendments. In our written submissions, we mention a lot about the practice directions and the user manual. So we hope that you will maintain a close dialogue with us when you firm up the latest bill or the relevant documents. Thank you, Mr. Martin Wong. I now invite the Hong Kong Law Society to give us their comments. Thank you, Chairman. The Law Society is grateful to the Judiciary Administration about this bill. They gave us positive responses on the comments from the legal profession, especially for the actual challenges facing the court remote hearing bill. The legal profession also noticed in mainland or in other jurisdictions, remote hearings are widely adopted, including civil proceedings and criminal proceedings. We welcome the judiciary's decision to put in place remote hearings at this stage. We also want the government to consider the wider application of remote hearings in due course. Within 6 months after the enactment of the bill. Well, I hope that the judiciary will more seriously consider a wider application of remote hearings. At this stage, the Law Society of Hong Kong supports all out the direction of the court remote hearing bill. On the application of technologies, that is actually quite demanding to the legal profession. This is a comment. I hope that you will give us more support so that we can upgrade or enhance in order to fulfill the requirement in relation to remote hearings. On the contents of the bill, I'd like to invite Mr. Stephen Hong, President and Chairman of Criminal Law and Procedure Committee, and Mr. Kenneth Fogg, Deputy Secretary General and Director of Practitioners Affairs. Mr. Stephen Hong, please. The Law Society of Hong Kong actually agrees with the judiciary. In criminal proceedings, the adoption of remote hearings is not quite viable on different fronts. These are not problems that could be solved overnight. So, in this connection, we see eye to eye. On other criminal proceedings, when we had a meeting with the Judiciary Administration, we said that we could try it out face by face. For example, for mentioned hearings, it might be easier to use remote hearings. I believe in the future, the judiciary will consult the Law Society of Hong Kong, and we can take a step-by-step approach. I'd like to say that for criminal remote hearings, that concerns the coordination of the CSD. CSD resources are also covered, are also involved. I hope that there will be support. In the absence of In the absence of support, the judiciary cannot implement remote hearings single-handedly. For criminal cases, it is not the case that the whole proceedings will be conducted by way of remote hearings. For criminal cases, it is the most important that we have open hearings. The Law Society of Hong Kong also had a comment that the audience need to register, and I think that there are actually issues when someone wants to sit in on a court hearing, then that person will have to register. Details have yet to be announced. But in terms of implementation, I think that there are issues right now. Open hearings are really open. That is to say, any one member of the public can walk in the court building, the courtroom, to sit in. So I do not understand why someone that wants to sit in on a remote hearing will have to register. I agree with the judiciary. For the first court appearance, the defendant should appear in person. But what about verdict? Does the defendant have to be present physically in a district court, in the high court, for magistracy appeal? We have been mentioning for a lot of years that there should be hand-down judgment. The law firm can just send any member of the firm to the courtroom, and then the judgment will be handed down. So I do not understand why the defendant in this case has to be physically present. To a certain degree, actually, remote hearings provide convenience to the defendants more than lawyers. I believe the lawyers would not mind going to the courtroom in the flesh. In my experience, I know that some defendants from a prison have to go to the courtroom for a hearing for as long as just 1 single minute, unlike members of the public who take minibuses to the courtroom. So remote hearings will actually appeal to defendants if they can choose. They may not want to go to the courtroom in person, knowing that the court proceedings are actually just a mentioned hearing. Thank you for your comments. I understand that remote hearings are something new, and we will have to group our way along the river. I agree that we have to take it step by step. We also need to tread cautiously. When it comes to legislative arrangements, for the Criminal Law and Procedure Committee, do you find this method acceptable? Yes, this is the case. Thank you, Chairman. Next, we have Mr. Richard Keedy.
The Law Society welcomes the increased use of remote hearings for civil proceedings, strongly supports the continued use of remote hearings in civil matters. There's been a strong take-up in the use of remote hearings in civil cases, both in the mainland and indeed in other common law jurisdictions. What that means for lawyers and for litigants is significant savings in travelling and waiting time. especially for shorter hearings, such as interlocutory and checklist hearings. Hong Kong is positioned as an international dispute resolution centre, and so it's appropriate that we do keep up with what other jurisdictions are doing in this space. The Law Society did have some residual concerns in relation to witnesses giving evidence remotely, and whether the part of the guidelines that deal with that indeed go far enough. There was also a concern that we had in relation to admission hearings. The bill in principle applies to admissions hearings, and the Law Society welcomes this, but it does give rise to some practical issues which we think require further consideration by the Judiciary Administration. Technology is changing the way that we work all the time. We think the judiciary and the profession must move with it. The future changes in technology may have an impact in the future, and we do need to bear those in mind.
Thank you very much for your input. Appreciate it. Thank you. 好，而家就對呢個提問嘅時間啦。
Now I open the floor. 3 members have pressed the request to speak button: Ms. Doreen Kong, Mr. Holden Chow, and Mr. Lam San-keung. We have ample time today, so each member can have up to 5 minutes. Ms. Doreen Kong. Thank you, Chair. I support the concept of remote hearings. I have got a few short questions. First, the concept of remote hearings must have all the supporting measures, including digital filing and also the technology setup of the court or the judiciary, and also manpower of the judiciary, the degree of acceptance of technology, and also the use of technology. I'd like to know how ready the courts are. Remote hearings will impact on the operation of small and medium-sized law firms. So I'd like to know whether there will be any assistance or support to these law firms, or have you been doing so already? According to the judiciary, you've already tried out 1,600 odd remote hearings. I'd like to know whether there was a rise in legal costs as a result. For the public at large, of course, remote hearings will provide convenience, but then the legal system is as well, and the legal costs are important. I'd like to know whether the legal costs will be higher or lower. In Part 2 of the bill, Clause 8, a number of factors will be considered. I don't see whether the number of parties will be considered. Will that be covered under P, any other relevant considerations? Because in other jurisdictions, they do take into account the number of parties involved. I agree with the principle of open justice. Now, if people have to register in order to follow a remote hearing, that goes against the principle of open justice. I'd like to know whether you can adjust this requirement so that no registration will be required. Judiciary Administrator. Thank you, Ms. Kong. Our responses are: first, I thank members for your support of the bill and the concept of remote hearing. We are going to proceed in a gradual manner after enactment of the bill. As regards technology requirements, we are already ready. Because of COVID-19, we conducted over 1,600 remote hearings in the past 3 years, and the experience has been positive and was smooth. At first, there were some hiccups, but then for civil proceedings, we had over 600 cases, and then we accumulated experience of different civil proceedings. We believe we'll be able to cope. Of course, there is always room for further enhancement, and we will keep doing so. We will maintain liaison with the sector. When it comes to whether there should be any support or financial assistance for small and medium-sized law firms, I believe during COVID-19, there was a fund to help small and medium-sized firms, and I think this question should be directed to the administration. In our 1,000 or so remote hearings, we did not see a very obvious increase in legal costs, but we will closely monitor the situation. For setup in courts, we want to facilitate people who take part in remote hearings, even those that are unrepresented, assuming that they cannot use those technology at home or it's not appropriate for them to do so. Will have a dedicated place in court to allow remote participation in a hearing. As for Clause 8 of the bill, factors to be considered. The number of persons involved in a hearing will also be considered, but we don't want to be too rigid about the number of persons involved because we have to ensure a fair hearing and to safeguard the rights of parties involved. These are important factors to be considered. Because whether the case itself is very complicated and the time allowed for the hearing, now all these will be considered by the court. Lastly, open justice. I think a few speakers have mentioned this point this morning. I think the Deputy Secretary was referring a Deputy Judiciary Administrator was referring to a rather exceptional case. Now, for members of the audience, they can just come to a court and they can follow the proceedings either in court or in a public place outside the court to follow a hearing. Now, if in a very exceptional circumstance, because of of public health or public order concerns, we cannot allow people to follow a physical hearing, and we don't want it to be a closed trial. And so in other jurisdictions, they have done this as well. We require registration because we need to provide a link. At least we must have an email for us to send the link to the person so that he can follow the proceedings. So it is needed as a matter of technology. We are not making it a routine requirement for people to be registered with the court in advance. Now, if indeed there is such a circumstance, then we will do so. But we believe that the situation requiring this will be rare. What about not allowing live streaming? If there is no registration, it will be difficult for you to find out whether there is any unauthorized live streaming. Mr. Holden Chow, I support the proposals. There are some questions as well as suggestions. Now, it is said in the paper that the judiciary will start with civil proceedings first, and for criminal proceedings, they have to wait. I agree to this approach because for criminal proceedings, you have to ensure that the person given evidence is not under any influence or direction or harassment if a remote hearing is conducted. Because if there is any hiccup, the whole arrangement will be affected and justice will also be at stake. So I believe we should start with civil proceedings. We have to be very cautious with criminal proceedings. And now I come to a question. Different members, including representatives from the Law Society, have said that if remote hearings become more common, then small and medium-sized law firms may need to invest in upgrading their technology. Of course, during the epidemic, there was the 50,000 INT fund for the legal sector. The sector has been asking for the fund to be regularized, or another fund should be set up for a similar purpose. It's always fine for large firms, but for small and medium-sized firms, if remote hearings is to be applied very extensively, I believe some of the firms may need time to be able to cope. They at least have to train up their staff. I note that there is this concern, that is, for members of the public to follow a remote hearing, they have to register with the court in advance. Now, in open court, now if you take a photo with your mobile phone, you will be immediately caught. But when it is a remote hearing, people can photo cap or screen cap with their mobile phone. So how can you catch unauthorized photo taking, etc.? You have penalty for such acts, but if you do not enforce the provisions, then the consequence can be severe, because if people publish the photos or publish the proceedings out of context, it can be rather serious. So it is important that people who do such things will be caught. Ms. Leung. Registration of the court to take part in or to follow remote hearing. Now we have raised the penalty to serve a greater deterrence, to let people know that unauthorized photo taking and publishing of court recordings or proceedings are serious offenses. And should such a scenario happen, registration of the court in advance is a way for us to follow, and we'll also invite the police to help. They have criminal investigation to handle these cases. And so we hope that from most remote hearings, members of the public can follow the proceedings physically in court, so that we can monitor whether they are doing any unauthorized acts, such as taking photos with their mobile phones for unauthorized publishing later. So this is just an option under exceptional circumstances, and we will minimize the occurrence of such cases. Mr. Lam San-keung, the sector is very concerned about digitalization of court services, and we welcome the presentation of the bill to the Council. Members as well as the Law Society are in support of the bill. I agree that technology-wise, we may not be able to ensure fair hearing and open justice in remote hearings. This is particularly so if an object or document has to be presented in a hearing. Now, we have already allowed a digital filing, but from what I understand, lawyers are not too eager to use this mode. Perhaps it's because the scope of application is not wide enough, and we should promote this mode. Hopefully, the two legal bodies can assist to enhance the technology setup of law firms, and we should also make use of the $50,000 INT fund for the legal sector. And we should have the right setup to keep abreast of the technology development in the 21st century. I will help to consult the sector as well. Thank you.
多謝主席，亦都多謝阿林議員。
Thank you, Chairman. Thank you, Mr. Lam, for his support. Mr. Lam mentioned the ICMS. Indeed, the integrated case management system is now being used in the district court, but for most civil cases heard in the district court, a lot of law firms are using this system. Right now, the registration rate is on the low side. I hope that the two legal professional bodies can promote this system to the legal trade. In the courtroom, our staff can provide guidance and assistance in relation to the use and registration of the ICMS. For remote hearings, an e-bundle can be used more widely. Thank you. Next, Mr. Paul Te. Thank you, Chairman. The low usage rate is not surprising. The legal trade is quite conservative. The Land Titles Bill has met with a lot of hiccups. There's a lot of objection. I hope that in the course of implementation, you have to have regard to our tradition, our practice, so do not pin too high hopes on us. We also want to see a longer transitional period so that there is enough time for us to get used to it. For the 50,000 of fund, I find it quite interesting, so to speak, and I find it a shame. If the legal trade is buoyant, then 50,000 is not quite a large sum. We are not banking on the $50,000 for existence. The environment is changing. We may lose our jobs with advancements in technology. There are pros and cons of technological advances. I'm not against any technological advancement, but you have to understand that there may be a substantial impact on the trade. Let us talk about technicality, be they criminal or civil hearings. For remote hearings or evidence collection, I am also concerned. As we understand, body language takes up 70 to 80% in face-to-face communication. During COVID, I wasn't quite passionate about remote conferences. Sometimes we speak something just in order to do so. We shouldn't make light of the importance of civil hearings. The veracity or whether a witness is telling the truth needs to be considered. I'm speaking off the cuff. I'm speaking from the bottom of my heart. But however good a speech is, probably a member is just reading off the script. In a remote hearing, without observation of the body language, lawyers will not be able to have a grasp of the feelings. In remote hearings, we have no understanding or idea about the surrounding environment of the person giving evidence. We have no idea whatsoever. It will be difficult for lawyers in a remote hearing, especially in the United States or in the UK. They are not willing to do so. That is because in a physical court setting, there are lawyers from both parties. There are also different persons. Then they do not have to spend a lot of time asking every single question. You can just take a look at the question, at the case being heard right now. When a lawyer cannot speak Putonghua, then the whole court, all the people in the whole court will have to speak Punti or speak in English. That is the case in the primary election case. With the current technology, it seems that we have to press ahead with the technologies. I'm not very sure about the pros and cons, but then it seems to me that we are doing so just because we want to do so. Are there things that we can change traditionally? If we do not change our system, the adoption of technology will only create more problems. But of course, regarding the major direction, I support it. But I think that we have to think how we can improve the court proceedings or make enhancements in these connections. Some responses. JA. Mainly, we conduct physical hearings. This bill just empowers the courts to adopt remote hearings when the situation is suitable. It does not mean that we will convert the majority of physical hearings into remote hearings. It is exactly because of this that there are many factors at play. The court will have to consider different factors. That is, will the witness be free from any interference, harassment, guidance, etc.? Or the witness cannot be seen. The surrounding environment cannot be seen. Mr. Porter also mentioned in proceedings, how can we streamline or simplify different proceedings or stages in proceedings, and these are also factors that the court will consider. Deputy Chair, Ms. Yonghua Yan. Regarding the adoption of remote hearings, I support this practice as well. I personally visited a court in Australia, and they also used remote hearings. In 2020 up to 2022, in Hong Kong, there were 1,600 odd cases, which were civil cases. They were conducted by way of remote hearings. During COVID, quite a lot of cases were conducted by way of remote hearings. Have you ever consulted judges or judicial officers or lawyers about what they feel about using remote hearings, or while they were making submissions or cross-examining witnesses? Have you consulted lawyers or JJOs? For legal practitioners, while cross-examining the witnesses, is there any difference between doing so in a remote hearing and in a physical hearing? How we cautiously use remote hearing technologies is a matter, but will it undermine our chance to see witnesses in person? Was that more difficult? Do they have a different perception? Will there be a lack of sense of reality if the remote hearing is adopted? Will it be less direct if the case is conducted by way of remote hearings? I believe that in the future there will be choices, which means that not all hearings will be conducted with the help of technologies. That is about implementation. Will you designate a hearing to be heard in a remote hearing? I'd like to understand the future implementation in this connection. My two questions first. Any response? Thank you, Chairman. Thank you, Ms. Yong. Over the last 3 years, we conducted 1,600 or so hearings. 1,000 through telephone, 600 through video link. The response has been very positive. This option provided convenience to them, especially in the midst of COVID. They did not have to come to the courtroom, but they could still attend the hearing. We have made quite a lot of enhancement in relation to equipment, even for persons outside of court premises. With a camera, or with more than one camera, there are different directions such that the surrounding environment can be seen by the court. We will continue with these technology enhancements. Even in a remote hearing, it will not be very much different from a physical hearing. But at the end of the day, the law protects litigants. Litigants will have a right to make their voices heard. There will also be submissions in relation to the remote hearing order. That is what cannot be done in a remote hearing and can only be done in a physical hearing. Individual cases will be handled on a case-by-case basis. This bill only provides a legislative framework so that litigants will then be able to make a choice. Simply put, we will still be treading very cautiously when we decide whether a case will be heard by way of remote hearings. Well, I have a follow-up. When Ms. Jung, you mentioned jury. Even upon the passage of the bill, criminal hearings will be heard with a jury. In the court of first instance in a high court, this will be exempted. That is to say, in the past 3 years, there were no cases that were heard with a jury. Well, I mean, there were no remote hearings where a jury was present. What about security concerns? You said that you could protect the communication of all parties within the legislative framework. Will there be any leakage of information? Will there be any interception of the hearings in the past 2 years? Have we looked into this aspect? Well, there was a response, but then you can make another response again. We have consulted the 2 legal professional bodies and some stakeholders on recording, publicizing, or live streaming the proceedings. I think, they think that we have to enhance the penalty, and the maximum penalty will have to be drastically enhanced, so as to highlight that this is outlawed. This will attract very serious criminal consequences, and we allow the public to come to physical hearings to sit in on a hearing so that we can monitor the situation. Only on very exceptional cases will we allow someone sitting in on a remote hearing. It will be more difficult to monitor the situation in this regard. So that is our major principle. Dr. Junice Ho, first round.
Chair, I fully support the use of remote hearing. because this will be in tune with development in reality. And then in recent years, because of the epidemic, we have enhanced use of remote hearings, and I'm grateful to the Judiciary Administrator for giving us the number of remote hearings conducted, and I think there is room for this to be further enhanced. Now I have a few questions. Are you concerned about security? In open trials, we don't have to worry about safety or security. I don't think people will be interested in sabotaging such open hearing, remote hearings, and so bugging is not a problem either. The problems are really serving of documents and digitalization of court records and how they will not be tampered with or altered. But these are not just about remote hearings. It's about the package of supporting measures. In the mainland, we can see the beauty of remote hearings. The mainland covers a vast area, and even the distance between provinces can be very great, and then remote hearings can save traveling. Another merit is we should digitalize a lot of things we have sadly lagged behind. Transcripts of hearings. Now, the verbatim records, whether we talk about English or Chinese, I believe they should be available very soon. In GBA, Greater Bay Area, court hearings are very convenient and expeditious, and verification of the identity is also easy so long as a lawyer is present, and then you can see at once what you have said. Now, even if your Putonghua is not perfect, your remarks can be corrected by the verbatim record. And before you leave, you have to check what you said on the transcript, and then everyone signs to confirm. So remote hearings are convenient. A few years back, it was because of the epidemic, but I think there is room for further development, not just because of the epidemic. For various reasons, the parties to proceedings may not be able to attend physically. This is particularly useful in civil hearings on when no jury is required. I commend the bill, and I think we should move faster even, because our judicial system has fallen behind. Ms. Low, thank you. Yes, we do not just look at remote hearings from the perspective of legal practitioners. It's also good for court users who are involved in simple hearings. So we will promote wider use of remote hearings in these cases. As for wider use of technology in court, this is our future direction. As for transcripts, we are carrying out some tests. In Hong Kong, cases are mainly heard in Cantonese. We have to attain a very high level of accuracy before the technology of sound to speech to words can be mature. We will use technology where appropriate. However, the accuracy of our transcript is something we want to ensure. Well, in the mainland, they do not just use Putonghua. There are different dialects, Hakkaise, Shanghainese, and also Cantonese. Your concern is about the technology being mature for attend for Pudawai. That's not really the case, and I think you should leave the worry to practitioners. Of course, you cannot have 100% accuracy. Thank you, Dr. Ho. Next, second round, 3 minutes each. Mr. Lam San-keung. Thank you, Chair. I'd like to take this opportunity to allow the public to understand more the merits of remote hearings. Before this meeting, we have consulted many practitioners, and I have also consulted mediators who use remote hearings as well. This is one way to enhance efficiency, and legal costs may be lowered as a result because we can save the traveling time and expenses for a physical hearing. But the reception quality is important. Before a hearing starts, the court and also the parties attending by remote mode will have to check the reception properly. Otherwise, the start of a trial may be delayed, and hopefully the two legal bodies can work with the court to ensure proper reception, because it's a waste of time if all of a sudden a party to hearing is lost and it takes time to recover him online, and you have to work with the service providers as well. It's just a view. There is no need to respond. Ms. Eunice Yong, 3 minutes. I'd like to ask a question about resources of our courts. I'd like to know whether part of proceedings that can be in a remote mode. For instance, the defendant is not physically present, and other parts of proceedings can take place physically in the court. And what about respondent or an applicant unrepresented legally? If the court has made a remote hearing order, where can people have the resources? You need to identify room in courts to allow applicants or parties to proceedings to attend in a remote mode. It can be inside or outside a court building. Now, if both parties need space, then where can you find the space? What will be the operational arrangements? If the defendant is outside Hong Kong, for instance, can he attend a remote hearing outside Hong Kong? Can you be more specific? Because it seems that there are still a lot of unknowns when it comes to the implementation of the bill. First, whether part of the proceedings can be held in a remote manner. Yes, under the bill, we allow part of the proceedings to take part in a remote manner, and some party to take part in a remote manner. It doesn't need to cover the whole proceedings. It can be in a mixed mode. As for people who are legally unrepresented, how can they take part in a remote hearing? Will enhance publicity. For instance, if he is in a place where a remote or digital linkage is not feasible, he can do so in a court. We provide such space in several courts, including our Queensway government offices. We have a support room to help defendant or parties without any legal representation. We will carry out technology trials to ensure that the effect is acceptable before we allow a remote hearing. So we will deal with each case on a case-by-case basis. We will help party without any legal representation. Mr. Paul Tse, it is mentioned in the paper that you have taken reference from other jurisdictions to ensure open justice and fair hearing. Can you tell us the jurisdictions you have researched into so that we can also conduct our own research? I think Dr. Junius Ho is always steps ahead of us in terms of participation in hearings in the mainland. Hong Kong is such a small city. The traveling time and distance to court is very different from the mainland, which is a very big place. And in the mainland, they may have all the outcome or findings of investigations in writing already. It is very different from what happens in Hong Kong. There has to be cross-examination or taking of evidence in court, and so we have to be very careful about this. I'm worried that open justice may be affected and there may be contempt of court. As a result, the government has created new offenses and new penalties. The media always very careful about commenting on sub-judice cases, but given the development of the internet, many KOLs are commenting on the evidence and also details of a case in progress. Now, we may have done a lot to prevent contempt of court or unauthorized recording or publishing of court proceedings or court hearings, but people outside Hong Kong doing the same will not be easily caught by our law enforcement agencies. Mr. Leung, thank you. We have taken reference from similar provisions in many jurisdictions, including the UK, New Zealand, Australia, Singapore, the US, and the mainland. When it comes to the bill in integrity, we have taken reference from the remote hearing law from New Zealand, and for other jurisdictions, they have incorporated such provisions into other pieces of legislation. Now, we have enhanced the penalty for unauthorized publishing of court hearings. We have to strike a balance. Now, Mr. Z referred to the contempt of court and also the commenting or criticizing court proceedings. This is already happening even without remote hearing. Remote hearing. Now, we will mainly tackle unauthorized recording or publishing of court proceedings. We will focus on such acts in the main. Any other questions? If not, do we have more comments from the Law Society and Bar Association? Mr. Ho. I think I'm on the same page with Dr. Junius Ho. Whether we have remote hearings or not, I think the crux of the matter is there is not enough personnel or resources on the part of the judiciary, we have talked about this for a long time. Do you have any measures to employ more judges so as to shorten the listing time for trials? Can the judiciary do more in this regard? And Ms. Yung's suggestion should be for the users. That is, for those or for judges who have used remote hearings. I think this is a very good suggestion. And the Vice President of the Law Society has suggested that we consult members of our society who have experience in remote hearings, and I believe we will provide the information to the judiciary for its reference.
你真係唔需要回應。
Thank you. It was just a comment. No response is needed. If no members have further questions to ask, we will call this discussion to an end. Any other business? No, there is no AOB. Meeting adjourned. Thank you, members. I also thank the Law Society of Hong Kong, Hong Kong Bar Association, and other officials for attending today's meeting. Thank you. Meeting adjourned.